Minutes to give your constructive speech on the practicability of legalizing divorce in the country.
Thank you. Why should we let couples stay together when each of them treats the other not as their better half, but their better half, to the point that one is abused and that human dignity is not respected? The practicability of passing a divorce law in the Philippines is anchored on the following principles. First, it fosters expediency and convenience to the parties. Divorce law caters to the myriad causes of marriage breakdown during the existence of marriage. As such, the need to prove that the marriage is void or defective from the very beginning or at the time of the celebration of marriage is not necessary and therefore dispensed with. But more importantly, divorce proves to be practical because it is a remedy available to the existing marriages in the Philippines that has arrived at an unfortunate end. This would favor those who are separated, in fact, by reason of grave spousal abuse or domestic violence. This means to say that the couples are given that opportunity to sever an already broken marriage. In the words of the Supreme Court, yes, Your Honor.
Is it your position that the regime of legal separation with the 10 grounds therefore is practically useless? Why or why not?
It's not practically useless, Your Honor. However, the remedy provided in legal separation is not sufficient because it does not actually sever the marital bonds. So therefore, the danger that the spouse might again condone the act of the husband of the husband or wife is still present in the status quo. But more, if I may continue, Your Honor, practicability requires adherence to public policy. A feasible statutory law upholds the core ideals of society. By passing a divorce law, deeper sense of societal responsibilities are advocated, and these are the prevention of illegal cohabitation and illegitimacy of children. Reality proves us that a person who is separated in fact or legally separated seeks another's arm for love, comfort, and support. Of course, this is inevitable because of human tendency to desire for love and to be loved. However, as we said, the present laws will not or cannot or is difficult, makes it difficult to happen because legal separation means only, as I've said, a separation from bed and board, while annulment and declaration of nullity rarely accommodates the causes of marriage breakdown during the existence of marriage. Yes, Your Honor.
Okay, Mr. Speaker, because you want a divorce here in the Philippines, can you give me at least 10 grounds in order that there will be a valid divorce from the worst to the lesser grounds?
There are the advantages, sir, or grounds of legal separation.
Yes.
Legal separation, grave spousal abuse, we can only give 2 grounds of legal separation: grave spousal abuse and psychological incapacity, which will be repealing Article 36 of the Family Code. So any problems which can actually be proven to be psychological incapacity can fit in that particular divorce ground. And the heartbreaking but true effects of illegal cohabitation would be having blessings but are branded as illegitimate children. Needless to state, illegitimate children are less favored by law, i.e. their shares of legitim, the right of representations, their proof of the stringent proof of acknowledgement. These are the things that cannot be that we wanted to avoid. With the passing of divorce, Your Honors, by passing of divorce, Your Honors, these will be unwanted consequences will at least be minimized, if not totally prevented. Because, as we said, the couples are given that opportunity to marry without legal impediments that will affect the status of the relationship and the status of their innocent children. With that, the affirmative had proven the necessity, the beneficiality, and the practicability of divorce law. With that, the affirmative rests its case.
All right. Thank you, Rhenan. Kimiko, 2 minutes to cross.
Rhenan, it is your team case that there is no mechanism for pre or post counseling in existing laws, correct?
Yes.
And that because of this, there is necessary to have a divorce bill.
Yes, there is necessary.
So in essence, you're using the lack of a counseling mechanism in existing laws. Wait. You're using the lack of and the existence of the express words pre and post counseling in existing laws to hinge and forward the case of
We have
divorce.
also stated the elimination of proving juridical antecedents.
All right,
in
next
cases
question though.
psychologically
Next
incapacity.
question though. If your problem is the lack of counseling in certain laws right now,
As I've
do
said,
you
we're
not
not
think
focusing on
it's practical that we can simply amend these laws to
Then
enter
by that you are
to
conceding
allow
to the
for...
fact that the laws are insufficient.
Wait,
Okay, because
Rhenan,
by
I'm
you
not
are just saying
even
amend.
done with the question yet.
Okay.
So do you not think that if your problem is the lack of pre and post counseling for annulment, that we can amend annulment grounds or amend annulment procedures to allow for this instead of a divorce bill?
We wanted severance of marital bonds.
What is the value then of your external bill if we can address your problem of no counseling and not buffering the effects to the spouses
We have
themselves?
forwarded a lot of beneficiality and necessity of passing a divorce bill, and we're not only focusing on post-counseling or
Alright, next question. You took too long. Should the state stand by a workable marriage, in your opinion?
pardon, Ms. Speaker.
Do you believe that the state should stand by a workable marriage?
Of course.
Of course. In a divorce, is it not true that a marriage is valid for all intents and purposes until something goes wrong?
Yes.
So there is an interval in the marriage where the marriage was workable in the running
Yes,
to
we could
the
see
breakup
that
of
there
this
is an
particular...
interval,
Yeah.
but we cannot foresee the negative.
You're done. Shouldn't the state find it more practical to prevent the breakdown of a marriage?
What
Why?
the law-
Before it even becomes that
what
bad.
the state protects
Before
is
it
a quality
allows
working
divorce.
marriage.
Alright, break it up, guys. Kimiko, 4 minutes now to rebut Rhenan and advance your argument.
So this is what it feels like to be on the other side. I used to be in SLU. Alright, so this is what Beda has to say about why divorce is flawed in principle. We say that the model is inherently impractical on 3 main levels that I will explain. We say it creates a dangerously open-ended paradigm because of its expanded idea of psychological incapacity. More than that, it's redundant. And more than that, it's hinging on Clifford's whole case that they don't have pre- and post-marriage counseling. That's why you need a divorce bill, which is rather non sequitur to begin with. So we say it's predicated on the notion that existent legal remedies aren't enough. They don't have counseling. So divorce is as an added alternative is the silver bullet to any and all marital problems. We say that's a problem solution mismatch. The solution is number 1, unresponsive to the real problems, and 2, it's redundant. The irreparable breakdown of a marriage happens in a timeline. In a divorce, there's nothing previously wrong with the marriage. It's valid for all intents and purposes until it actually breaks down. But this doesn't happen overnight. It's brought about by events that happen and transpire during the pendency of the marriage. These are problems that add up over time. This presupposes that there was an interval of time prior to marital collapse when issues were not hopelessly unworkable. The state could have stepped in to stop the marriage from breaking down. Yes, sir.
Madam Speaker, my question is, if you are a married woman, then a battered wife, will you not file a divorce if we have divorce law in the Philippines?
No, sir, because I would look at all remedies possible. That's what the state should let me do, and that's what the state should encourage me to do. Going on, this is where we feel that the state should step in this pivotal moment where the marriage is not yet totally unworkable and that the marriage can be saved, so you don't have to get to the point of needing divorce. You should prevent the exacerbation of conflict, you should encourage reconciliation, and you should save the marriage. This is the difference between annulment and their setup of divorce. Because in annulment, or how it's done in status quo, the point of reckoning is from the problem back to the inception of the marriage. There's nothing to save because the marriage was never valid to begin with. But in divorce, the time of reckoning is from the problem onwards to the marital collapse, which we say we can do something about in the interim. It's not practical. Yes, sir?
Do you agree that psychological incapacity as a ground for voiding a marriage is actually utilized as a divorce provision? Why or why not?
Yes, sir, it is. But there are inherent safety mechanisms. For example, you have to prove its gravity, its juridical antecedents, and its incurability, as opposed to what they want, where they cut out all these restraints because they want to make it expedient. So we say it's not practical to incentivize the tragedy by simply waiting until the problems become that bad when you could have prevented it in the first place. It's impractical for the state to dissolve a marriage that it could have saved in the first place. It's a misaligned thrust. If you want a new option because you think you don't have counseling, then amend your laws. If you think it's hard to procure, then give your OSG the sufficient mechanism because it's 800 cases filed every month in the Office of the Solicitor General. You're only delayed because the OSG doesn't have the machinery to quickly investigate collusion. If your problem is violence and 19 battered women every day, according to the statistics of House Bill 1799, your penal laws are sufficient. You need only exhaust the remedies. And finally, if your problem is a lack of a clear idea on the intricacies of marriage, then we say the answer to your problem lies not in creating a divorce bill, but you educate your people. So it's redundant on these levels. First of all, because we think that the mechanism merely mirrors an already existent mechanism. In fact, the already existent mechanisms are even better. Second of all, it's intrinsically disagreeable. We heard no standards or assurances from them that this will graft seamlessly with the culture of the Filipinos in the first place. So at the end, we say that this will militate against, this will militate against the constitutional mandate to err on the side of a marriage's validity, especially since we can step in and prevent it from breaking down in the first place. Thank you.
All right, Rhenan, your turn to cross-examine Kimiko.
I don't need to give a lot of questions because I think they have already considered the insufficiency of the law's status quo. Well, but Miss Parable, family is a fount of love, respect, happiness, mutual help and support, isn't it?
Yes.
Yes. If a husband beats his wife, is the respect. If a husband beats his wife, constantly beats his wife, is the respect.
No, but it's not answerable by divorce.
If a husband abuses his wife physically or emotionally, is there love? Is there
No,
love
but
to
it's
speak
not
of?
answerable by divorce.
No way. If a child sees her parents constantly fighting each other, is there happiness in that family?
Does divorce make them more agreeable parties? No.
You would agree with me that without love, happiness, and mutual respect, then there is no marriage or family to speak of that the state seeks to protect.
No, I don't agree.
You don't agree. But is this the kind of family, as I said, that the state seeks to protect?
The state
Is
seeks
this
to
the
protect
kind of
valid
family?
families.
Is this, yes or no answer? Is this the kind of family that the state seeks
It's
to
not
protect?
answerable by yes or no. The state will protect
Now
a
you
valid
agree with
family.
me that severing the marital relationship is necessary in practical
I never
aspect.
said that.
You concede, right? You wanted to concede. Actually, here, your mind may not concede
go ahead,
with me,
explain.
but your heart has already conceded. Your heart has already conceded. That's all.
My heart conceded.
Your mind has not conceded, but
married?
your heart has already conceded.
Thank you, Rhenan.
All right, thank you all very much. A very spirited and amusing debate indeed, and lots of tough questions from Judge Pampilo. Thank you all very much. May I invite everyone to stand up and cross the house as our judges tally the scores. Square off the CVC law debates will return after these messages. Now let's ask our judges to critique the performances of our two teams. Attorney Galasio, what did you think of the affirmative side, the St. Louis University?
I would like to congratulate the affirmative side for the quality and passion by which you presented the arguments in support of your proposition in this exciting mental calisthenics. You were wise and clever to have circumscribed the parameters of your, to have limited the parameters of your proposition, and you limited the grounds, and you even provided post-divorce decree remedy. You veered away from the concept presented even in the pending House Bill 1799. In that way, you were able to somehow mitigate the impact of your proposition, and more importantly, you were able to minimize exposure from various fronts for interpellation. So with that, congratulations.
All right, and Attorney Santos, what can you say about the negative sides on Beda College-Manila?
I would like to commend the Bedans. First, you presented very solid arguments. You also gave out laws and jurisprudence. You were very good in your interpellation. I think you will be very, very good lawyers in the future with the way you handle cross-examination.
Square off. We'll be right back with the results. Please stay tuned.
Industries Philippines, Figaro Coffee Company, ATR Kimeng Financial Corporation, RCBC,
Welcome back, and now for the results. Let's hear from our chief adjudicator, Judge Pampilo. Your Honor, who did the judges pick as best speaker?
Okay, for the best speaker, after we have a consultation with my co-judges, and we have a very hard time choosing the best speaker because all of the speakers are very, very good, and we are very, very impressed with them. And they are very adamant on their position, and even in interpretation, they're very, very good. But despite that, there is the best.
Out?
Okay.
Yes.
So the best is from Beda, Joseph Peter Kaliak. Congratulations on the best speaker. You will become, see you in my court. You will become a very good lawyer.
All right, and Your Honor, who won?
For the debating team, the best, both are very, very good. But,
Okay.
but you
But
know.
there can only be one winner.
Yes, one winner. And in fact, 3 judges, we are very impressed with the St. Louis University. They are the best debating team. Congratulations, guys.
Congratulations to St. Louis University, the University of St. La Salle Bacolod, and the University of the Philippines will face off next week. I'm Mike Yoreta. Thank you for watching.